Please be seated. Good afternoon. The sitting is now open. The court meets this afternoon to hear Turkey, the Islamic Republic of Iran, Jordan, Kuwait, and Luxembourg on the questions submitted by the General Assembly. Each of the delegations has been allocated 30 minutes for its presentation. The court will observe a short coffee break after Jordan's presentation. I shall now give the floor to the delegation of Turkey. I call Dr. Nu Ilmaz to the podium. You have the floor.
Mr. President, before I proceed with my statement, I would like to extend my sincere congratulations to you and your election as the President of the Court. Mr. President, distinguished members of the Court, we appear before you today to deliver our oral submission a year after our testament on the legal consequences of Israel's occupation of Palestinian territories. On July 19, 2024, this respected court issued an advisory opinion stating that Israel's continued presence in the occupied Palestinian territories, including East Jerusalem, was illegal and that Israel was under an obligation to bring this unlawful occupation to an end as rapidly as possible. On September 19, 2024, UNGA adopted Resolution 1024 endorsing the advisory opinion of the ICJ. This resolution underlined that all states are under an obligation not to recognize as legal the situation arising from the unlawful presence of Israel in the OPT, and not to render aid or assistance in maintaining the situation created by the continued presence of Israel in OPT. The court's past orders, provisional measures, and advisory opinions have consistently recorded the unlawful acts of the State of Israel and called on Israel to comply with international law. The reason we appear once again before the court is Israel's sustained breach of its international obligations, which have been further aggravated since October 2023. We have been confronted with a war of unprecedented scale against civilians in Gaza. The Israeli aggression is spilling over to the West Bank and also to neighboring countries, above all Lebanon and Syria. The international community has gravely failed to halt the Israeli aggression and the loss of tens of thousands of innocent lives in Gaza, mostly women and children. Initially, the ceasefire agreement of January 15th brought much-awaited relief for both sides. The release of Israeli hostages and more than 1,700 Palestinian detainees, the entry of humanitarian aid, and the reopening of return routes to northern Gaza for the displaced revived Palestinian hopes for an end to this unprecedented suffering. Yet, the agreement was later nullified by Israeli non-compliance. Israel once again opted for hostility instead of peace. In its current form, the Israeli aggression continues unabated with grand schemes for the depopulation of Gaza, the annexation of West Bank, the enlargement of illegal settlements, and deportation of 2.4 million Palestinian refugees in Gaza to third countries. The people of Gaza are again under a blockade, this time with zero entry of humanitarian aid. Collective punishment is enforced in the name of forcing Hamas to return the hostages. Israel uses hunger as a weapon. Israel sweeps hundreds of thousands of displaced people from one place to another within minutes of evacuation orders. Israel targets houses, hospitals, schools, shelters, camps, safe zones, and all remaining civilian infrastructure. Most recently, Israel blew up the Turkish-Palestinian Friendship Hospital, Gaza's only specialized cancer treatment hospital, as well as adjacent medical school on March 21st. Where there is no law enforced to stop Israel, there is chaos, anarchy, and mass killings amounting to genocide in Gaza, which appears imminent to be replicated in the West Bank without immediate international intervention. According to the UN, in the West Bank, more than 50,000 people have been displaced following Israeli military operations against the Jenin camp, which expanded to the Tulkarim, Nur Shams, and Al Farah camps. Israeli Minister of Defense Israel Katz has declared that the military will remain in these camps throughout the coming year and that the residents will not be allowed to return. Mr. President, esteemed members of the court, UNGA adopted resolution 79-232 on December 19, 2024, requesting the ICJ to render an advisory opinion based on Article 96 of the UN Charter and Article 65 of the Statute of the Court. This resolution sought an advisory opinion from the ICJ to clarify Israel's obligations as an occupying power and as a UN member in relation to the presence and activities of the UN, including its agencies and bodies, other international organizations, and third states in relation to OPT. Turkey submitted a written statement pursuant of the court's order of February 27, 2025, in accordance with Article 66, paragraph 2 of the Statute of the ICJ. Turkey's support for this request underscores its commitment to ensuring that Israel adheres to its international obligations. Among these obligations is the responsibility to allow unimpeded access to humanitarian aid, essential supplies, and basic services for the Palestinian civilian population in the OPT. Additionally, Israel is required to facilitate the work of international organizations. As a UN member, Israel must act in good faith to fulfill its obligations under the Security Council and UNGA resolutions, which include compliance with the UN Charter and the requirement to implement UN Security Council resolutions. Turkey's position is anchored in key international legal instruments, including the UN Charter, international humanitarian law, and international human rights law. Several principles are particularly relevant in evaluating Israel's obligations in the OPT. Under Articles 2, paragraph 3 and 2.4 of the UN Charter, all member states, including Israel, are obliged to resolve disputes peacefully and refrain from the threat or use of force. These obligations extend to cooperating with the UN in maintaining global peace and security, ensuring that international norms are upheld. The privileges and immunities granted to the UN, its agencies, and personnel are essential for ensuring their independent and impartial functioning. They stem from the 1946 Convention of the Privileges and Immunities of the UN. Turkey underlines their importance, particularly in the context of humanitarian operations in the OPT. The inviolability of UN organizations is crucial for their ability to assist the Palestinian refugees effectively. Israel, as the occupying power in the OPT, is bound by the Fourth Geneva Convention of 1949, which stipulates the protection and welfare of civilians under occupation. These obligations include ensuring that humanitarian aid reaches the Palestinian population without obstruction, respecting the presence and work of the UN, international organizations, and third states providing aid and upholding the rights of Palestinians under international humanitarian and human rights law. Turkey maintains that Israel's compliance with these obligations is necessary for achieving peace and stability in the region. The basis for responding to the questions brought before the court for an advisory opinion is the state of Israel's UN membership, which is yet to be accorded to the state of Palestine as per foundational UN resolutions. During the 207th plenary meeting of the UN in 1948, Moshe Sharett, the Israeli foreign minister of the time, reaffirmed Israel's commitment to the UN principles, emphasizing peace, cooperation with neighboring Arab states, and adherence to international obligations. Israel assured that its policies align with the UN Charter and relevant resolutions, leading to its recognition as a peace-loving state willing and able to uphold its obligations. However, despite its commitments, Israel has not implemented UNGA resolutions, obstructed the establishment of a Palestinian state as outlined in UNGA Resolution 181, and denied refugees their rights under Resolution 194. These violations continue to challenge Israel's adherence to its UN obligations, particularly as more countries recognize Palestine as a state. Article 4.1 of the UN Charter sets 5 conditions for membership: being a state, being peace-loving, accepting the Charter's obligations, having the ability to carry them out, and demonstrating willingness to do so. The ICJ affirmed these criteria is an advisory opinion, underscoring that UN membership requires continuous compliance with the Charter's principles. Failure to uphold these obligations may lead to accountability under international law. UNGA and UN Security Council resolutions stress the need for states to protect UN personnel and facilities, particularly in conflict zones. UNGA Resolution 337 reaffirmed the safety of UN personnel, while UN Security Council Resolution 1502 condemned attacks against them as violations of international law. Additionally, UN Security Resolution 2286 specifically condemned attacks on medical personnel and facilities during armed conflicts, urging member states to safeguard humanitarian actors. Furthermore, the 1946 Convention of the Privileges and Immunities of the UN explicitly guarantees the inviolability of UN premises, archives, and assets, ensuring the organization's ability to operate independently and fulfill its mandate. Under the Geneva Conventions, which both Israel and Palestine are parties to, civilians and humanitarian personnel must be protected during conflicts. Common Article 3 stipulates humane treatment for those not actively engaged in hostilities, including UN staff. The ICJ has ruled that the Geneva Conventions apply to all occupied territories, rejecting Israel's claim that they do not apply to de jure to the OPT. Articles 104 and 105 of the UN Charter further reinforce the legal protections afforded to the UN, granting it legal personality and ensuring its ability to function without state interference. Israel, as a party to the 1946 Convention, is obliged to respect these provisions. Moreover, Article 2.5 of the Charter requires Israel to assist in the UN in its activities rather than to obstruct them. Israel, having ratified these provisions without reservations, is legally bound to respect UN premises, personnel, and missions. These privileges are granted to ensure that the UN can effectively carry out its mandate. Despite these obligations, Israel has restricted access of UN personnel in the OPT, including East Jerusalem. The Independent International Commission of Inquiry on the OPT has reported Israeli non-cooperation in UN investigations, blocking entry of officials and medical professionals. The Special Rapporteur on the situation of human rights in the OPT noted that Israel's refusal to grant access to UN investigators may constitute obstruction of justice. The Office of the High Commissioner for Human Rights has also reported that Israel denies visas to international staff working in the OPT. The ICJ has emphasized the importance of UN immunity and the obligation of states to respect and protect UN personnel. The 1949 advisory opinion on the reparation for injuries suffered in the service of the UN affirmed that attacks on UN agents hinder the organization's mission and constitute violations of international law. The ICJ recognized the UN's right to claim reparations for injuries suffered by its personnel and upheld the principle of implied powers, which allows the UN to take necessary actions to fulfill its duties, even if not explicitly stated in the Charter. As of September 19, 2024, it was reported that Israeli authorities stopped issuing visas to heads and staff of the international NGO community. As the UNRWA Commissioner General has underlined, quote, the government of Israel has been phasing out representation from humanitarian organizations or those engaged in reporting on the atrocities of this war and the impact on civilians. As humanitarian needs to continue to increase, we need more humanitarian workers, not less. The opposite is now happening, end quote. In fact, this came on top of the ongoing entry ban of international media to report freely from inside Gaza at a time when also a number of senior UN officials are not given permission to visit Gaza and or are prevented to travel to the West Bank, including East Jerusalem. Among these senior UN officials is UN Secretary General Antonio Guterres, who was declared persona non grata by Israel on October 2nd, 2024, and banned from entering the country and effectively the OPT. The unilateral decision of the Israeli government to completely stop the transfer of humanitarian aid to Gaza as of March 2nd, 2025, constitutes a form of collective punishment against all civilians in Gaza. This action goes against Israel's obligations as the occupying power in Gaza, as outlined in the 4th Geneva Convention to ensure access to humanitarian assistance. This policy of collective punishment has been reconfirmed in a written statement issued on April 16, 2025 by the Minister of Defense of Israel, stating that the blockade on aid to Gaza will be maintained in order to exert pressure on Hamas to release the remaining hostages. Additionally, several Israeli ministers have reiterated their harsh rhetoric calling for the policy of no aid in Gaza until the release of hostages. The Israeli Knesset voted on February 19, 2025 to approve in a preliminary reading the amendments to the association's bill. The said amendment stipulates that organizations receiving any funding from foreign entities and are not budgeted by the State of Israel will be subject to an 80% tax on every donation received from such a foreign source. The draft bill essentially aims to cut international donations destined for Palestinians in the OPT. The Israeli failure to implement its international obligations has been most flagrant in its long-time targeting of UNRWA and its public services to Palestinian refugees. The agency was established through UNRWA Resolution 3024 in 1949 as a subsidiary UN body tasked with providing essential services and humanitarian assistance to Palestinian refugees across its operational territories, including the OPT encompassing East Jerusalem. Following the 1967 conflict, Israeli authorities formally requested UNRWA's continued presence in these territories through a Comey-Michel-Moore agreement. Despite its critical humanitarian role, UNRWA has faced significant challenges due to Israeli policies and actions that have hindered its operations. These include movement restrictions on UNRWA personnel, arbitrary arrests, military operations targeting UN facilities, and the blockade on Gaza. UNRWA has documented incidents where Israeli forces have violated the agency's neutrality and inviolability, including attacks on its facilities and personnel. For example, in 2009, Israel bombed UNRWA's compound in Gaza, destroying humanitarian supplies. In 2013, an UNRWA staff member was killed by Israeli forces in the West Bank. According to OCHA, as of April 15, 2025, at least 417 aid workers, including 294 UN staff, have been killed. These, combined with Israel's approach toward UNRWA since the events of October 7th, represent an unprecedented attack to the immunity and privileges of the UN and severely restrict humanitarian aid to Gaza and the West Bank. Furthermore, these actions violate multiple international legal instruments, including the Fourth Geneva Convention, which obliges an occupying power to ensure humanitarian assistance and basic services to the civilian population. The ICJ has also issued provisional measures requiring Israel to allow humanitarian aid into Gaza, which Israel's actions directly undermine. Regarding the situation in Gaza, Israel's legislative actions further violate the three sets of provisional measures ordered by the ICJ in the case of South Africa versus Israel, January 26th, March 28th, and May 24th, 2024. The said orders specifically required Israel to desist from actions creating conditions calculated to bring about the physical destruction of the protected Palestinian population and to facilitate unfettered humanitarian assistance to Gaza. The prohibition of UNRWA operations in Gaza, given the agency's status as the primary provider of humanitarian assistance to the civilian population, is a violation of the provisional measures and constituting the destruction of Palestinians as a protected group. UNRWA Resolution 7678 and the previous resolutions have condemned attacks on UNRWA facilities and reaffirmed the inviolability of UN premises. The Security Council has also passed resolutions urging Israel to respect international law and ensure humanitarian access. Furthermore, the UN Secretary General has reiterated Israel's obligations under the 1946 General Convention on Privileges and Immunities, emphasizing that UNRWA's operations must be protected. While barring UNRWA operations, Israel has failed to provide any alternative humanitarian mechanism for the 2.4 million Palestinian refugees in the OPT. Under Article 55 of the Fourth Geneva Convention, Israel is legally bound to ensure access to food, water, and medical care. However, reports from the international bodies, including the UN Human Rights Council and the Independent International Commission of Inquiry, document systematic Israeli violations of these obligations. The killing of a Turkish-American national, Ayşenur Ezgi in the occupied West Bank during peaceful protests further highlighted the grave risks faced by humanitarian aid volunteers in the OPT. Mr. President, distinguished members of the court, today we appear before the ICJ to make a plea for justice, which in this case means peace and security for both Palestinians and Israelis. We seek to remain within the boundaries of the questions posed by the court by UNGA. It is of grave concern that since the submission of our written statement in late February, Israeli aggression has once again flared up. According to UNRWA, since the collapse of the ceasefire in Gaza, following the Israeli aerial strikes in Gaza on the night of March 17th and 18th, 2025, intense military activities and assaults have continued, killing and injuring hundreds of people and further damaging and destroying what remains as civilian infrastructure, including hospitals. Over 180 children were reported killed on March 18th, marking one of the highest single-day child death toll over the last year, according to UNICEF. On March 19th, 2 UN guest houses were hit in Deir el-Bala in Gaza middle areas, killing 1 team member of the UN ops and injuring 6 more UN staff, some of whom sustained life-altering injuries. Humanitarian aid and supplies have not entered the Gaza Strip since March 2nd, when the Israeli authorities reimposed the siege. This siege has now lasted over 8 weeks, surpassing the duration of the total siege imposed in October 2023, when hostilities first started. As a result, critical humanitarian supplies, including food and medical aid, have been rapidly depleting. Israel's imposed restrictions on aid delivery to Gaza, which have proven particularly deadly for children, could have been prevented had UNRWA maintained its full operations throughout Gaza and the occupied Palestinian territories. In the West Bank, large-scale operations of the Israeli forces that started in the Jenin camp and other areas in the north on January 21st is ongoing, making it by far the single longest operation of the Israeli forces in the West Bank since the Second Intifada and causing the largest population displacement since the 1967 war. Against this backdrop, 2 developments are particularly concerning for the ICJ's mandate to provide an advisory opinion. First, due to the unbearable Israeli attacks on Gaza, which also target UN humanitarian workers, the UN Secretary General has taken the difficult decision to reduce the organization's footprint in Gaza. This is a blow to international efforts to restore Israel's international obligations in the OPT. Second, on March 23, 2025, 8 Palestinian medics, along with 6 civil defense first responders and a UN staff member, were killed by Israeli forces in southern Gaza. 5 ambulances, a fire truck, and a UN vehicle were struck one by one in the El Hashashin area, and their bodies were recovered from a mass grave. Even worse, the preliminary investigations point to deliberate executions at point blank. This was yet another instance of Israel's deliberate attack on humanitarian aid workers and UN personnel. Humanitarian organizations demanded accountability, calling the attack a war crime. The UN and aid groups have urged an investigation, emphasizing the protection of medics in conflict zones. Turkey is deeply concerned about Israel's persistent non-compliance with its obligations under international law. On top of its incessant crimes against the Palestinian people, Israel's obstruction of humanitarian aid, targeting of UN facilities, and harassment of UN personnel not only exacerbate the suffering of the Palestinian people, but also compromise the rule-based multilateral system, undermines the credibility of the international legal order, and seriously weaken the effectiveness of international bodies such as the UN and legal instruments such as the 4th Geneva Convention. Such actions must be addressed by the international community urgently to ensure accountability and justice. Therefore, Turkey respectfully requests the ICJ to issue an advisory opinion that reaffirms Israel's obligations under international law, paves the way for taking measures to prevent further violations of these obligations, and underscores the importance of respecting the presence and activities of the UN, other international organizations, and third states in the OPT. This court bears a legal, historical, and moral responsibility to reaffirm Israel's obligations under international law and the illegality of actions taken against the UN and its agencies, including UNRWA and other international organizations. Turkey shall remain fully committed to supporting a just and lasting solution to the Israeli-Palestinian conflict. Thank you.
I thank the representative of Turkey for his presentation. I now invite the next participating delegation, the Islamic Republic of Iran, to address the court. And I call upon His Excellency, Mr. Kazem Garibabadi, to take the floor.
Bismillah ar-Rahman ar-Rahim. Mr. President, members of the court, it is indeed an honor to appear before you on behalf of the Islamic Republic of Iran. The Holy Quran says, من أجل ذلك كتبنا على بني إسرائيل أنه من قتل نفسا بغير نفس أو فساد في الأرض فكأنما قتل الناس جميعا ومن أحياها فكأنما أحيا الناس جميعا. That is why we decreed for the children of Israel that whoever kills a soul without its being guilty of manslaughter or corruption on the earth is as though he had killed all mankind, and whoever saves a life is as though he had saved all mankind. As the principal judicial organ of the United Nations, this honorable court is once again called upon to address fundamental yet persistently overlooked rights of the Palestinian people. These include the right to urgently needed supplies essential to their survival, as well as of basic services and humanitarian and development assistance, the right to humanitarian access and basic necessities of life, as referred to the question put to the court as per General Assembly Resolution of 19th December 2024. However, as we do not deem the Israeli occupying regime a legitimate member of the United Nations due to the illegality of its formation, we focus on violations of the Israeli regime in light of its prolonged occupation of Palestine and ongoing genocide, particularly in Gaza. As a preliminary remark, given Article 96 of the United Nations Charter, Para 1 of Article 65 of the Statute of the Court, and the Court's jurisprudence, we submit that the jurisdiction of the Court is evident and that there are no compelling reasons for the Court not to exercise its jurisdiction. Mr. President, it is too late. All the evidence points unequivocally to genocide. The window, if any, to stop the ongoing genocide in Gaza is rapidly closing. The question before the court does not concern an ordinary armed conflict. It deals with a genocidal situation, and as such, it requires a response to address its specific circumstances. The court has already decided in its orders of provisional measures more than 1 year ago that the Israeli occupying regime must, among others, I quote, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, end quote, and to take, I quote, all necessary and effective measures to ensure without delay, in full cooperation with the United Nations, the unhindered provision at a scale by all concerned of urgently needed basic services and humanitarian assistance, including food, water, electricity, fuel, shelter, clothing, hygiene, and sanitation requirements, as well as the medical supplies, end quote. 1 year past the prolonged recalcitrance of the genocide and inaction of the international community at this juncture constitutes an absolute moral and legal failure. According to latest reports, around 52,000 Palestinians have been killed as martyrs and over 123,000 wounded since October 2023, a toll that rises daily and a direct result of pursuing the declared policy of dehumanization by the Israeli occupying regime. These are not mere numbers. They represent innocent children, women, the elderly, and families, an entire nation under siege, being systematically decimated. As these proceedings unfold, OCHA reports that no aid has entered Gaza since 2nd of March. Medical supplies are rapidly depleting, including critical stocks for maternal and child health, as the number of aid workers killed since October 2023 has reached 412. Meanwhile, UNRWA and other humanitarian actors face systematic obstruction in delivering aid. The disaster is currently so frustrating that on 7th April, the heads of OCHA, the UNICEF, the United Nations Office for Project Services, UNRWA, WFP, WHO, and IOM issued an urgent appeal to world leaders to act firmly and urgently to save Palestinians in Gaza, with a high-level United Nations official says that, I quote, "We are being deliberately blocked from saving lives in Gaza, and so civilians are dying," end quote. How much more must the world witness before recognizing the genocidal intent behind these atrocities, including the infliction of severe bodily and mental harm, the deliberate imposition of conditions calculated to bring about Palestinians' physical destruction? All the aforementioned is just a fraction of the decades-long Israeli regime's crimes in Palestine. Dozens of United Nations resolutions, reports, and decisions, alongside the dicta of this court in numerous advisory and contentious proceedings, have affirmed the illegality of occupation and the imperative of unimpeded humanitarian access. Yet these rulings and appeals have gone unheeded, as inhuman acts persist with devastating consequences. This totality of actions has, in our view, created a sui generis situation, demanding an equally sui generis response, specifically tailored to end the prolonged occupation, stop the genocide, save lives, secure the right to self-determination of Palestinians, and bring criminals to justice. Mr. President, members of the court, in our oral statement today, we submit that obstruction of humanitarian aid constitutes a violation of international humanitarian law. It further violates Palestinians' fundamental rights. Commission of international crimes both contribute to and result from obstruction of humanitarian access. And we finally submit that the United Nations, other international organizations, and third states are under an obligation to ensure Palestinians' access to humanitarian aid. Meanwhile, given the unprecedented gravity of the ongoing genocide, our arguments will demonstrate a clear nexus between obstruction of humanitarian aid and its human consequences, and the international community's obligation to prevent genocide. Mr. President, members of the court, as an occupying power, the Israeli occupying regime has systematically and repeatedly obstructed access to civilian population in flagrant violation of international humanitarian law, including provisions of the Hague Regulations 1907, as well as the Fourth Geneva Convention of 1949. Article 43 of the Hague Regulations, as well as Articles 23, 33, 47, 50, 53, 55, and 56 of the Fourth Geneva Convention, unequivocally account for the obligations of the Israeli occupying regime, including to cooperate with the United Nations, its agencies and bodies, other international organizations, and third states to ensure Palestinians' access to urgently needed supplies essential to their survival. Among these provisions, Article 43 of the Hague Regulations is particularly pertinent, expressly requiring the occupying power to, and I quote, take all measures in its power to restore and ensure, as far as possible, public order and safety of the occupied territory, end quote. Moreover, Article 55 of the Fourth Geneva Convention is explicit in obliging the occupying power to ensure the food and medical supplies of the civilian population. Mr. President, members of the court, the Palestinian people in Gaza and the West Bank in particular have been deprived of the basic necessities essential to their survival, leading to violation of their fundamental human rights to life, water, food, and health, among others. First and foremost, right to life, especially in Gaza, has become a mirage. Killing is occurring on a daily basis. The threshold under Article 2 of the Genocide Convention was crossed a long time ago. With deliberate targeting of civilians, all belonging to a group, as well as the deliberate obstruction of humanitarian and vital for their survival, genocidal intent is beyond evident. Apart from direct death, what has been underreported is indirect death that add significantly to the gravity of the situation, in particular in Gaza. According to a recent study, deaths due to traumatic injury in the Gaza Strip between 7th October 2023 and 30th of June 2024 reflect an exceptionally high mortality rate, underscoring the urgent need for interventions to prevent further loss of life. Concerning violation of Palestinians' right to water as a result of blocking humanitarian access, apart from a scarcity of clean, fresh water in Gaza for more than a decade due to destruction of water and sanitation infrastructure, in October 2023, the Israeli occupying regime closed the water pipelines into Gaza and cut off the electricity needed to run the desalination plants that process the brackish water that flows from the coastal aquifer. According to WHO, poor access to fresh water has resulted in water-related diseases such as hepatitis A, which is typically acquired by consuming contaminated food or water. What has deteriorated the water tragedy in Gaza, specifically during the past year, has been the brutal devastation of United Nations structure for water, sanitation, and hygiene in the Gaza Strip, demonstrating the Israeli occupying regime's direct targeting of humanitarian aid from the United Nations, even prior to recent years' strikes. The question remains as to how this cannot be seen as evidence of genocidal intent by the Israeli occupying regime. As regards Palestinians' right to food, the OCHA announced in November 2023 already that Gazans were at a high risk of starvation, further stating that it was incapable of providing adequate food, water, and medical care to meet Gazans' needs. As another example, as early as March 2024, a report was released by the Integrated Food Security Phase Classification Famine Review Committee, stating that widespread famine would be imminent in Gaza, and there would be, I quote, a major acceleration of death and malnutrition, end quote. Mr. President, members of the court, more than a year has passed since this catastrophic phase, and the situation has only deteriorated as starvation and willful obstruction of humanitarian aid causes serious bodily harm to Palestinians, again in contravention of the Genocide Convention. Mr. President, members of the court, Gaza's health system has also been debilitated by the Israeli regime. At least 627 healthcare workers are known to have been killed, 212 have been arrested, and 47 ambulances have been destroyed or damaged through targeted attacks. By January 2024, the Israeli regime had already bombed every one of Gaza's 12 universities, in what may be called a full-fledged escolaticide, ironically, at a time when the need for doctors has never been so urgent, no medical student has been able to graduate. What is even more staggering is the often neglected psychological effects of the Israeli regime's actions on the well-being of civilians in Palestine, and in particular in Gaza. Years of exposure to violence, displacement, and loss have led to a burgeoning mental health crisis with chronic stress, PTSD, depression, and anxiety becoming endemic, living in the Gazan children particularly vulnerable. The impact of this psychological trauma is profound. In such a crisis, blockade of access to medical care of the United Nations, other international organizations and entities is a blatant disregard for fundamental principles of international law by the Israeli occupying regime, significantly undermining the Palestinians' right to health. This constitutes a literal violation of Article 2 of the Genocide Convention as its terms are breached verbatim by the Israeli occupying regime. Mr. President, distinguished members of the court, international crimes being committed by the Israeli occupying regime in Palestine have appeared as a cause and effect of obstruction of humanitarian access. These include, among others, genocide, war crimes, and crimes against humanity. This pattern is reflected in the ICC prosecutor's application for arrest warrants against Israeli criminals and the pending proceedings before this honorable court regarding alleged violations of the Genocide Convention. War crimes have become a routine by the Israeli occupying regime, particularly in Gaza Strip. Attacks against civilians, including United Nations staff, medical personnel, as well as journalists, deliberate targeting of civilian infrastructure and medical facilities, and imposing collective punishment on the civilian population are only part of the war crimes committed by the Israeli occupying regime in the last year. According to the United Nations, up to 1.9 million people in Gaza are internally displaced, including people who have been displaced 9 or 10 times. From the perspective of displacement, the present-day ethnic cleansing of Gaza can be compared to the 1948 Nakba of Palestine. This, among others, is a clear instance of crimes against humanity, especially when coupled with obstruction of humanitarian access. More concerning still is the estimate provided by the United Nations and other organizations about increasing numbers of newborns on brink of death. The United Nations highlighted hunger, starvation, and famine as the cause of such deaths as a result of extensive restrictions by the Israeli regime on the entry and distribution of humanitarian aid and commercial goods, mass population displacement, and the destruction of crucial civilian infrastructure. Such measures are intended to prevent births among Palestinians as an instance of genocide under Article 2 of the Genocide Convention. According to another report by the United Nations Independent International Commission of Inquiry in Palestine, the Israeli regime has perpetrated a concerted policy to destroy Gaza's healthcare system as part of a broader assault in Gaza, which is evidence of commission of the crime against humanity of extermination. Such policies and practices have systematically denied humanitarian access to United Nations agencies and other relief organizations, precluding the delivery of vital assistance to civilians, a pattern appearing both as a cause and effect of obstruction of humanitarian access. Mr. President, members of the court, to conclude, the question put to the court on its face concerns humanitarian access to a civilian population. In a situation of armed conflict, however, we are faced with a genocidal situation here. it is indispensable for the court to opine on humanitarian access to a people targeted by genocidal acts and the ensuing obligations of the international community to stop them. In its judgment of 26 February 2007 in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, Bosnia and Herzegovina versus Serbia and Montenegro, the court clarified the content of the duty to prevent genocide under the Convention. In the court's opinion, responsibility is incurred, I quote, if the state manifestly failed to take all measures to prevent genocide which were within its power and which might have contributed to preventing the genocide, end quote. The court further considers the first parameter to be, I quote, the capacity to influence effectively the action of persons likely to commit or already committing genocide, end quote. In the court's view, I quote, a state's obligation to prevent and the corresponding duty to act arise at the instant that the state learns of or should normally have learned of the existence of a serious risk that genocide will be committed. From that moment onwards, if the state has available to it means likely to have a deterrent effect on those suspected of preparing genocide or reasonably suspected of harboring a specific intent, it is under a duty to make such use of these means as the circumstances permit, end quote. Mr. President, we ask if there is a state that has not learned of the existence of a serious risk that genocide would be committed in Gaza. What have those states that are in a position to prevent genocide done to fulfill their duty under the Convention? We regard obstruction of humanitarian aid by the Israeli occupying regime as, among others, evidence of genocidal intent and invite the court to clarify a state's duties to ensure Palestinians' humanitarian access in view of a state's obligation to prevent genocide under the Genocide Convention. Having said that, notwithstanding the present proceedings, the rules are clear. Obligations of states and international organizations are evident, and the international community has again failed. This is the failure of the United Nations system, the United Nations member states, and that of humanity. This failure has already been registered in the archives of human history due to and because of supremacy of politics over rule of law. Lastly, this statement shall in no way imply our recognition of the Israeli regime. I thank you, Mr. President.
I thank the representative of the Islamic Republic of Iran for his presentation. J'invite à présent la délégation.
I would now like to invite the delegation of Jordan, and I call upon Professor Marcello Cohen to make his presentation. Mr. President, members of the court, it is an honor to appear before you on behalf of the Hashemite Kingdom of Jordan and to reiterate its written statement and conclusions in which we list all of Israel's obligations that are the subject of this request for an advisory opinion. Jordan is particularly concerned by the issues under discussion here. The Hashemite Kingdom hosts 2,400,000 Palestinian refugees registered with UNRWA on its territory. It is the custodian of the Muslim and Christian holy sites in Jerusalem and is at the forefront of providing humanitarian assistance to the population of the occupied Palestinian territory. Jordan maintains diplomatic relations with both the State of Israel and the State of Palestine and works tirelessly for peace in the Middle East. Since the submission of the written statements, the situation has worsened dramatically as a result of the breakdown of the ceasefire, the ban on humanitarian assistance to Gaza, and Israel's actions in the West Bank. Hence the importance and urgency of this advisory opinion. I will briefly address the question of the exercise of advisory jurisdiction by your court, and then I will examine the impact of the principle of self-determination on the various aspects of the question posed by the General Assembly. My colleagues, Eric Bjorge and Alfredo Crisato, will address United Nations law and humanitarian assistance, respectively. Mr. President, there are decisive reasons for the court to exercise its advisory jurisdiction. The United Nations has a permanent responsibility with regard to the Palestinian issue until all its aspects have been settled in accordance with international law. The arguments put forth against the exercise of your jurisdiction are unfounded, namely that there is a risk of prejudging the outcome of a pending dispute. Secondly, that the question has already been dealt with by the court in its 2024 advisory opinion. 3, that the question is one-sided and hence would not take the context into consideration. 4th argument, that the court would not have the necessary factual information. It suffices to say here that the case of South Africa versus Israel concerns exclusively the Genocide Convention, whereas the question raised in the present instance relates to Israel's obligations in a more general context. The question also differs from those already answered by the court in 2024. Last year's advisory opinion provided valuable legal elements to better answer the question now put to the court. It is a question which was not raised by the General Assembly in its previous request. Indeed, the question refers solely to Israel's obligations because it is Israel and no other state which occupies the Palestinian territory. The question asked is limited in scope. It does not seek to address all issues related to the persistence of the occupation or the situation arising from the 7th of October 2023. The General Assembly, like the Security Council and your own court, has already demanded the immediate and unconditional release of the hostages held in Gaza. This situation does not relieve Israel of its obligations under international law. Furthermore, the question posed concerns legal obligations, and the court has the necessary factual elements that would enable it to rule on them. If Israel has grievances against the United Nations or its organs, the Convention on the Privileges and Immunities of the United Nations provides it with the necessary means to take action. Mr. President, members of the court, the principle of self-determination is of paramount importance in responding to each of the elements of the question posed. Indeed, respect for the implementation of this right by the Palestinian people is the backdrop against which all other obligations incumbent on Israel must be interpreted and applied. It further requires Israel, in the current circumstances and in accordance with its obligation, not to impede the realization of this right and to take all necessary and effective measures to protect the Palestinian civilian population. As self-determination is a fundamental principle of international law, a right erga omnes, and a peremptory norm of international law, Israel's obligations are not only towards the Palestinian people, but also towards the United Nations competencies in this matter and towards the international community as a whole. As stated in Article 1 of both the Human Rights Covenants, and I quote, "In no case may a people be deprived of its own means of subsistence, unquote. Israel's obligation to respect the Palestinian people's right to self-determination is without exception. The powers granted to Israel as an occupying power under the Hague regulations of the Fourth Geneva Convention cannot be exercised to the detriment of the peremptory right of self-determination. In case of armed conflict, only the rules relating to the protection of human beings have been considered by your court as peremptory principles of customary international law, and the occupying power must respect them. As the court has affirmed, the powers granted to the occupying power are for a temporary occupation, not for an extended occupation, which constitutes a de facto permanent annexation in violation of the principle of self-determination. Israel has an obligation to cooperate with the United Nations, other international organizations, and third states to bring to an end its illegal presence in the occupied Palestinian territory as soon as possible in order to enable the Palestinian people to fully enjoy their right to self-determination, to cease all activities that prevent the exercise of that right, and to act positively to facilitate it. This includes the obligation to respect its territorial integrity, preventing any form of displacement of its components and refraining from any change in the demographic composition of the territory, and ensuring and facilitating the unhindered provision of emergency supplies essential for the survival of the civilian population, as well as the provision of basic services and humanitarian and development assistance. Israel also has an obligation to respect the permanent sovereignty of the Palestinian people over their natural wealth and resources, and not to impede the diplomatic, consular, and other relations of third parties and international organizations with the Palestinian authorities. The Knesset adopted a declaration stating that it opposed the establishment of a Palestinian state, and it did so just a day before your court issued its advisory opinion in July 2024. This declaration by the Israeli parliament is once again in flagrant contradiction with the right of the Palestinian people to self-determination. All organs of the State of Israel have an obligation to respect this right and not to obstruct the exercise of this right. In this sense, there is an obligation to repeal any legislative or administrative provision aimed at preventing the realization of the right to self-determination. Mr. President, members of the court, there is no justification for the continuation of the Israeli occupation of the Palestinian people, which prevents them from exercising their right to self-determination. The first relevant obligation is therefore to respect that right and to seize its violation. It is only through strict respect for international law and not through expansionism or oppression or force that problems can be solved. The best guarantee for peace in the entire Middle East is a two-state solution that respects the independence and security of both states. Thank you for your attention, Mr. President. I now request you to give the floor to Professor Eric Bjork.
Je remercie le professeur Cohen. I now invite Professor Eric Bjork to address the court. You have the floor.
Mr. President, members of the court, it is an honor to appear before you on behalf of Jordan to address Israel's obligations under the law of the United Nations. I make 4 points. First, Israel's obligation to respect the privileges and immunities of the United Nations. Second, Israel's obligation to give the United Nations every assistance. Third, Israel's obligation to cooperate with other states. And fourth, Israel's obligations regarding the safety and security of United Nations personnel. First, Israel has an obligation to respect the privileges and immunities of the United Nations. Israel recognized in the exchange of letters with UNRWA of 1967 that a number of facilities were essential for the agency to operate effectively. The fact that Israel recognized these facilities as essential indicates that they are, pursuant to Article 105 of the Charter, necessary for the fulfillment of UNRWA's purposes. The General Assembly has recalled that the agency, as a subsidiary organ of the United Nations, enjoys the benefits of the Convention on the Privileges and Immunities of the United Nations. The main provisions of the General Convention anyway reflect customary international law. I will deal with three of these. The immunity from every form of legal process set forth in Section 2 is essential for the independent exercise by UNRWA of its functions. The inviolability of UNRWA premises set forth in Section 3 guarantees that the premises may not be entered and that the United Nations must itself be permitted to control activities occurring on those premises. All UNRWA officials enjoy immunity and the privileges set forth in Section 18. The provisions relating to officials in the General Convention apply to all staff members, the only exception being those recruited locally and assigned to hourly rates. Those criteria are cumulative. The immunity of UNRWA from every form of legal process and the inviolability of its premises are absolute. They may not be qualified or overridden by military expediency or national security. Israel has an absolute obligation to respect the privileges and immunities of the United Nations. Israel self-evidently has an obligation, inter alia, not to enter UNRWA premises, not to damage or destroy such premises, not to detain UNRWA staff without charge or trial, and not to seek to extirpate the agency from the occupied Palestinian territory. Second, the text of Article 2, paragraph 5 of the Charter is to the effect that Israel has a general obligation to give every assistance to the United Nations. State practice, including that of Israel itself, confirms this. The contention by Israel that the obligation relates only to enforcement action taken by the Security Council has no basis in international law. The interpretation for which Israel now contends runs counter to the clear wording of Article 2(5) and is inconsistent with the court's interpretation in the reparations case. Israel has an obligation to give UNRWA every assistance in any action it takes pursuant to the provisions of the Charter. There is a further aspect. Judge Lauterpacht was correct in voting procedure, where he observed that a state which ignores a series of General Assembly resolutions acts at its peril when a point is reached, when the cumulative effect of the persistent disregard of the articulate opinion of the organization is such as to foster the conviction that the state in question has become guilty of disloyalty to the principles and purposes of the Charter. Israel is obliged to give the Charter, Israel is obliged under the Charter to give due consideration in good faith to the resolutions of the General Assembly. In whaling in the Antarctic, the court adopted this reasoning in respect of the Whaling Convention. It applies no less to the Charter. Israel has the obligation to give due regard to General Assembly resolutions, notably those adopted in the 10th Emergency Special Session. Third, one of the purposes of the United Nations is, according to Article 1, paragraph 3 of the Charter, to achieve international cooperation in solving international problems of a humanitarian character. As Judge El Arian observed, the principle of international cooperation in Article 1, paragraph 3, is, like the other purposes and principles of the United Nations, a legal principle, binding on states. The Charter recognizes this in Article 14, to which the court was taken this morning, and which addresses the situation of, I quote, a violation of the provisions of the present Charter, setting forth the purposes and principles of the United Nations. End of quote. This obligation to cooperate was developed in greater detail in the Friendly Relations Declaration. Its fourth principle lays down the duty of states to cooperate with one another in accordance with the Charter. Fourth, Israel's obligations as regards the safety and security of United Nations personnel. Israel has obligations in this regard under the rules of customary international law codified in the Convention on the Safety of United Nations and Associated Personnel. That this convention codifies customary international law is evident from the fact that the General Assembly adopted it by consensus. Notable in this regard is Israel's obligation to facilitate the unimpeded transit of UNRWA and other United Nations personnel across its own territory. This obligation includes unimpeded transit from one part of the occupied Palestinian territory to another. Israel also has the obligation to ensure the safety and security of United Nations personnel, to release detained personnel, and to penalize crimes against them. Israel has, finally, the obligation not to make UNRWA or other United Nations personnel the object of an attack or any other action that prevents them from discharging their mandate. That, Mr. President, members of the court, concludes my presentation. I thank you and ask that you invite Professor Alfredo Crossato to the podium.
I thank Professor Bioge. I now give the floor to Professor Alfredo Crossato.
Thank you, Mr. President, members of the court. It is an honor to appear before you on behalf of Jordan. I shall now focus on Israel's obligations concerning humanitarian relief in Gaza. These arise from a variety of sources that include the law of occupation, human rights law, the law on the protection of persons in the event of disasters, and this court's orders on provisional measures. All told, international law requires Israel to provide humanitarian relief to the civilian population of Gaza, a territory which is at present far from adequately supplied. Indeed, a humanitarian catastrophe is already unfolding, where Israel is unable or unwilling to fulfill its duties. It must facilitate relief schemes undertaken by third parties. Time is of the essence, and Israel must do so swiftly and in cooperation with the third parties involved in good faith. Let me start with the law of occupation and two general remarks. First, the court recently reaffirmed that the law of occupation applies to the entire Palestinian territory, including Gaza. That situation has not changed, and any contention that Israel does not currently occupy Gaza must be rejected. Israel has not been liberated from its obligations as an occupying power. Second, the scope of Israel's claimed authority as an occupying power. Whatever the situation, international law does not confer such an authority or discretion, allowing a state to circumvent obligations aimed at ensuring the survival of a civilian population. It is impossible to conceive a good faith interpretation.
I'm sorry to interrupt you, but could you speak more slowly?
Sure.
Thank you very much.
It is impossible to conceive a good faith interpretation of the law of occupation consistent with its object and purpose that would result in widespread suffering of civilians and destruction of civilian objects. The court has determined that Israel's occupation is illegal. Its policies and practices, I quote, manifest an intention to create a permanent and irreversible Israeli presence in the OPT, breaching the provision of acquisition of territory by force and the principle of self-determination. You also found that Israel has engaged in a sustained abuse of its position as an occupying power. Any territorial control still exercised by Israel until it has withdrawn must therefore ensure the well-being of Palestinians and respect for the right to self-determination. Moreover, since Israel has been abusing the law of occupation, it cannot claim broad rights or powers arising from it. This is a core legal consequence of the general principle prohibiting the abuse of rights. Israel's relevant obligations are primarily found in the Fourth Geneva Convention and customary international law. As long as Israel occupies Gaza, the customary rule reflected in Article 43 of the Hague Regulations requires it to act for the benefit of the local population. This is a general guiding principle and fundamental duty of Israel. Article 55 of the Fourth Geneva Convention requires Israel, to the fullest extent of the means available to it, to ensure the food and medical supplies of the population, including by bringing in the necessary foodstuffs, medical stores, and other articles, if the resources of the occupied territory are inadequate. Article 69 of Additional Protocol 1, which reflects custom, expands the range of supplies that must be provided. Under Article 56, Israel must ensure and maintain the medical and hospital establishments and services, public health and hygiene, and allow medical personnel of all categories to carry out their duties. Article 50 mandates the facilitation of the proper working of all institutions devoted to the care and education of children. The Convention also contains key provisions concerning third parties when the occupying power does not or cannot fulfill the obligations I just mentioned. Where Israel fails to act, civilians are not left to their own fate without more. Article 59 stipulates that if the occupied territory is inadequately supplied, the occupying power shall agree to relief schemes on behalf of the population and shall facilitate them by all the means at its disposal. Such schemes may be undertaken by states or by impartial humanitarian organizations and shall consist in particular of the provision of consignments of foodstuffs, medical supplies, and clothing. These are erga omnes obligations of both result and conduct. Israel cannot oppose those relief schemes. Agreement is the required outcome, no exception. Israel must also facilitate those schemes using all available means. This is a high standard of conduct consistent with the gravity of the situation that Article 59 addresses, prohibiting Israel from actions or omissions that may hinder humanitarian relief. Article 59 must be read together with Article 1, which contains states undertaking to respect and to ensure respect for the Convention in all circumstances. Every state party must ensure compliance by Israel with its obligations, while respecting, of course, other rules of international law. Article 59 is a form of application of Article 1, a means for states to ensure...
Excuse me to interrupt you. Please, speak more slowly.
A means for states to ensure compliance with Israel's relief obligations. When states seek to provide relief schemes, individually or jointly, they do not do so only by virtue of an option envisaged by Article 59. They have an obligation to act of their own. Article 59 may require practical arrangements for the orderly supply of humanitarian relief. Insofar as these are needed, Israel must consider them in good faith, bearing in mind the needs of civilians. Arbitrary or unjustified delays would not be consistent with Article 59. They would defeat the purpose of the obligation. In the present circumstances, Jordan, like virtually all participants, considers that Gaza is inadequately supplied. This is manifest, and that Israel's obligations have been triggered. Jordan is also of the firm view that UNRWA meets the principles of impartiality and neutrality, as confirmed recently by the Colonna report and the OIOS investigations. Furthermore, there is no other actor that could realistically replace the agency and its mandate to provide and distribute humanitarian relief and other services in Gaza. Israel must therefore allow UNRWA to continue its humanitarian operations and cease all conduct which prevents the agency from doing so. There is no other way to give full effect to Article 59 of the Convention in the circumstances. Israel's obligations, as we noted, also arise from other sources. These are separate obligations which complement and are as stringent as the law of occupation. I will address a few key ones. Israel must ensure the right to life of Palestinians consistent with the ICCPR and the Convention on the Rights of the Child, which apply in Gaza. This includes a positive duty to take action to prevent foreseeable harm or injury that may result in arbitrary deprivation of life. In the present context, such risk is not only foreseeable, but already materializing. To avoid further loss of life, Israel must strictly respect the fundamental principles of IHL and facilitate humanitarian relief in Gaza. The Covenant on Economic, Social, and Cultural Rights requires Israel to ensure the right to an adequate standard of living, the right to the highest attainable standard of physical and mental health, and the right to education. These rights are at risk of being altogether denied to Palestinians in Gaza, and Israel must take immediate action and allow the supply of relief to prevent such denial. Jordan has also referred to the law on the protection of persons in the event of disasters, recently codified by the ILC. The obligations in this area are closely linked to those under human rights law and require Israel, among others, to cooperate in good faith with third parties, to facilitate humanitarian assistance, and not to arbitrarily withhold consent to such assistance. Finally, Israel has obligations arising from the interim measures in the South Africa-Israel case. It must take all necessary and effective measures to enable the unhindered provision of basic services and humanitarian assistance in Gaza. It must do so as a matter of urgency, without delay, and in cooperation with the United Nations. The obligations we have addressed should be interpreted and applied in a systemic manner and against the background of the principle of self-determination, which is of paramount importance. Time, again, is of the essence, and Israel must perform its duties swiftly and in good faith. The horror that Palestinian civilians are undergoing in Gaza must stop. Mr. President, members of the court, this concludes my presentation and Jordan's oral submissions. We thank you for your kind attention in these important proceedings.
I thank the representatives of Jordan for their presentation. Before I invite the next delegation to take the floor, the court will observe a coffee break of 15 minutes. The hearing is suspended.